Welcome. It is Thursday night. This is Why Libertarian. I always want to play with, this is like our kind of like fireside chat or our like, teaching evening every 2 weeks on Thursday for Natural Rights Talk. And I always want to be like, welcome to Natural Rights Talk. Like it's like some fireside theater or something. So anyway, anyone who is new to this program, my name is Matt. This is Why Libertarian. Please like, comment, subscribe, share, hit the notification bell, retweet. We are streaming on the blockchain. I am on Odyssey right now. I am on the Hive blockchain on vim.tv. So if you are on those platforms, definitely throw me a follow and an upvote. That would be very, very appreciated. And I'm not monetized on any of the traditional social media websites. So if, that's the only way I really get any kind of remuneration for doing this. So definitely flip me an upvote on the blockchain if you are on any of those. And check out the top link. If you go to my link tree, scrolling on the bottom, top link, I'm giving away May 31st. In 18 days, I'm giving away 100 Hive. That is a crypto giveaway. I will do one every single month. This one in May is the Hello, Introduce Yourself, Get into the Liberty Community on Hive giveaway. So to qualify for that, definitely check out that top link in my link tree, and that video will walk you through everything. Or go to my pinned tweet on my Twitter, and that will give you a thread of instructions on how to get into that giveaway. All right, all that being said, we have our friend Josiah here again. Josiah, how's it going?
Good. How are you doing today?
Very good. Very good. So tonight we are chock full of stuff tonight. So we are talking about American bodies politic. We are talking about citizenship, right? Like American citizenship. And then we are talking about, I'm going to stumble through this one again. Lexicographic falsification. How did I do?
That's perfect.
Close enough, right? So we have a lot to roll through. So the first thing that we're talking about is the origins and the nature of the American bodies politic. So what exactly is the bodies politic to begin with?
So this is just essentially like a very brief and general history of the states.
Okay, and so where do we begin with it? Let me throw up our notes for this evening, if I can find it.
Well, just wanted to mention again, in case anybody hadn't seen the previous episodes, this is coming from the American Natural Rights Foundation. And this is a lot of the stuff that we basically are interested in getting the people educated about.
That is a very good point. And remind everyone what the website is for ANRF.
It's actually, because we're based in Montana, it's actually mt-anrf.com or org. Sorry.
So MT as in Montana dash ANRF.org. Awesome.
That's
All
right.
right. So kick us off here. Let me try and while you read, I'm going to try and magnify this so everyone can see it.
All right.
But go ahead and kick us off.
All right. So a proprietary colony was a type of English colony, mostly in North America and the Caribbean, in the 17th century. Under the proprietary system, individuals or companies were granted commercial charters by the monarchs of the Kingdom of England to establish colonies. In the British Empire, all land belonged to the monarch, and so all colonial properties were partitioned by royal charter into one of four types: proprietary, royal, joint stock, or covenant. A charter is a grant of authority or rights, stating that the grantor formally recognizes the prerogative of the recipient to exercise the rights specified. It is implicit that the grantor retains superiority or sovereignty, and that the recipient admits a limited or inferior status within the relationship. And it is within that sense that charters were historically granted, and it is that sense which is retained in modern usage of the term. A colonial charter is a document issued by a sovereign or state outlining the conditions under which a corporate body is organized and defining its rights and privileges. King Charles II used the proprietary solution to reward allies and focus his own attention on Britain itself. He offered his friends colonial charters, which facilitated private investment and colonial self-government. The charters made the proprietor the effective ruler, albeit one ultimately responsible to English law and the king. Charles II gave New Amsterdam to his younger brother, the Duke of York, who named it New York, and gave an area to William Penn, who named it Pennsylvania. The charters defined the relationship of the colony to the mother country as free from involvement from the crown. For the trading companies, charters vested the powers of government in the company in England. The officers would determine the administration, laws, and ordinances of the colony, but only as conforming to the laws of England. Proprietary charters gave governing authority to the proprietor, who determined the form of government, chose the officers, and made laws subject to the advice and consent of the free men. All colonial charters guaranteed to the colonists the vague rights and privileges of Englishmen, which would later cause trouble during the Revolutionary era. And in 1772, an articulation of those rights written by Samuel Adams, right, called "The Rights of the Colonists," was published. And if you remember, we read, the section about their rights as men when we talked about man in the state of nature.
Yes. Yeah.
So,
and that was, I believe it was 2 episodes ago. And to your point, that is an interesting element of, the development eventually of how, the individual states viewed rights of the individual and how essentially they were getting screwed by the crown, right?
Yeah, see, the rights of this Declaration of the Rights of the Individual is, in the name of the colonists, is actually like the first Declaration of Independence before the Declaration of Independence, which has more to do with the states. Yeah.
Yep. Yeah.
So these proprietors then selected the governors and other officials in the colony. The Lord Proprietor usually exercised his authority almost as an independent sovereign. The provinces of Maryland, Carolina, and several other colonies in the Americas were initially established under the proprietary system. These colonies were distinct from crown colonies in that they were commercial enterprises established under authority of the crown. Proprietary governors had legal responsibilities over the colony, as well as responsibilities to shareholders to ensure the security of their investments. And some of the characteristics of proprietary or self-governing colonies include that they swore an oath to the king, but ruled the colony independently. They were granted autonomy when the kingdom was at risk. They observed responsible government in that they utilized parliamentary democracy. They guaranteed to colonists the rights and privileges of Englishmen. They were self-governing in that they had a locally elected representative government. They presumed no authority or control over the sovereign or the political relationships held with other colonies, and there was an ultimate avenue of appeal in matters of law and justice in the form of a judicial committee of the Privy Council. So the English sovereigns sought to concentrate their power and authority, and the colonies were converted to crown colonies. Royal or crown colonies were those that, in the absence or revocation of a private or proprietary charter, came under the direct, everyday governmental control of the English monarch. There was no local autonomy, and citizens had no representation in local government. In theory, their purpose, from the royal perspective, was in some ways similar to that of a medieval fiefdom. That is, for the foremost function of a royal colony was to benefit the English crown. Although most colonies started out as private or proprietary ventures, the majority became royal, usually through revoked or time-limited charters well before the Revolutionary era. By the mid-18th century, all of the 13 colonies had become royal or crown colonies. So crown colonies are of three types, with representative council, with a nominated council, or ruled directly by a governor. So some of the characteristics of crown colonies include that the governor and members of the council are chosen by the sovereign. There was no local autonomy, and citizens had no representation in the local government. The council was split into distinct legislative and executive spheres, and even included a judicial committee as the ultimate avenue of appeal. The 13 original colonies' first major act of independence was forming the Stamp Act Congress of 1765. At this meeting, colonial leaders rejected the tax because they had no representatives in British Parliament, creating the phrase "no taxation without representation." Mm-hmm. Tensions between Great Britain and the colonists steadily increased, fueled by incidents such as the Boston Massacre in 1770, the Declaration of the Rights of Colonists in 1772, and the Boston Tea Party in 1773. The British hit back by passing a series of punitive laws and restricting self-governance in the government in the colonies. In late 1774, a group of patriotic leaders at the Continental Congress meeting set up their own government to resist Great Britain. On July 4th, 1776, the 13 colonies declared themselves free and independent states at the Second Continental Congress by signing the Declaration of Independence. On May 15th, 1776, the Second Continental Congress created the first continental system of government, the Articles of Confederation. The Articles created an assemblage of pre-existing states, as opposed to a government over, of, or by individuals. The states received equal representation in the Confederation, regardless of the size of population. The Articles created a single Congress exercising legislative, executive, and judicial powers, and the powers of this Continental Congress were limited to those expressly enumerated in the Articles. To act, Congress required a supermajority of the 13 states. Only amendments could endow the Confederation with powers not expressly granted, and amendments required the approval of all 13 state legislatures. Because of territorial disputes between two states, the Articles did not come into operation until March 1781.
So Josiah, we have a big fan of the Articles of Confederation, Shane T. Hazel, watching at the moment. I don't know if you're familiar with Shane, but Shane's going to be running for governor down there in Georgia next year.
Wow,
yeah, he ran for U.S. Senate this past year. So, but yeah, big fan of the Articles of Confederation. And let me ask you, I think hopefully this isn't a preconceived notion or anything, but I think a lot of people have been taught that the imperialism of the crown essentially spread them too thin. And so it seems like what happened at first was these colonies were kind of set up in good faith, and then once there was essentially financial struggles on the part of the crown, they decided to essentially call an audible or change the arrangement. Is that right, or is that off?
I think so, but I'm not in particular. I have not studied the Articles of Confederation as much as I've studied a lot of the more historical and legal points.
Sure.
But yeah, to my understanding, yeah, I would agree with that.
Because it sounds like they were originally set up under one charter, and then it was changed on them?
Well, I know there's quite a lot of different things I know that kind of played a role, and I'm not exactly sure how much, I'm not exactly sure how much that, played a role, but surely.
Okay, awesome. All right, so let's see, Madison's views?
Yeah, so Madison's views of the appropriate position of the states emerged even more strikingly in Yeats' record of his speech in June 29th in 1833. I'm not sure how that got in there. I think that's accidentally the date of the site.
Oh, that's fine.
It's Yeats. whatever, Yates' record was 33. But anyways, some contend that the states are sovereign when in fact they are only political societies. There's a gradation of power in all societies, from the lowest corporation to the highest sovereign. The states never possess the essential rights of sovereignty. The states, at present, are only great corporations, having the power of making bylaws, and these are effectual only if they are not contradictory to the general confederation. So essentially, the people, each in their particular political community, and remember, those are Republican communities, right? Where, the people are the sovereign. Right. So as it concerns relations between independent political communities, the state represents the sovereignty resident in the people. And so actions taken by the state actually do represent actions in the name of sovereignty. But in relation to the people, the state is simply a corporate political body and acting as their agent,
Right. And with essentially a voluntary relationship, right, between that corporate body and the individual sovereign.
Correct, almost.
Okay.
So we'll talk about that in the next part where we talk about American citizenship.
Awesome.
Yeah. So just to finish up here, counties and municipalities were and still are charter governments in the name of civil corporations with the power of making bylaws for their own interior regulation, and with such special authorities as are given them in their charters of incorporation. A corporation aggregate consists of many persons united together in one society, of which kind are the mayor and commonalty of a city, the head and fellows of a college, the dean and chapter of a cathedral church. So essentially, some of the characteristics of a civil corporation is that they were not liable for damages for negligence in the performance of public duties except through legislative enactment. They were no more than public agencies of the sovereign to assist in the conduct of local administration. And they had no power to decline the functions devolved upon them or to withhold performance of them in the mode prescribed. Also, something interesting to note about corporations is that no person can be forced to be a member of a corporation without his consent. That's kind of like what we were talking about, voluntary, but we're going to kind of delve deeper into that when we talk about citizenship.
Well, yeah, and we can talk about, I would imagine we're going to delve into kind of the contractual relationship therein, right?
It's not actually contractual. It's actually natural. It's a natural political relationship that occurs as a consequence of the natural law.
Okay.
So American citizenship, you want to just keep going?
Go for it.
So if you remember, I read an excerpt, I'm not sure if it was last time or the time before, but it was from a case from 1795. And I'm going to read that case again, but I'm going to include a couple other excerpts from other cases that kind of expanded on that original idea. So inasmuch as every government is an artificial person, an abstraction and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. The contracts between them involve U.S. citizens, which are deemed as corporate entities. Therefore, the U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. So a U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident and does not have the common law right to travel of a citizen of one of the several states. And so through a series of legal developments in our early history, which is really just more sophistry, right? You remember what sophistry is? Yeah. The term citizen became interchangeable with the term subject. So, and most legal professionals would actually agree, with this interpretation because of an old principle in the English common law called jus soli. So Lord Coke, an English barrister, judge, and politician, thought that natural law led to jus soli. And in a famous case on the issue, it was determined that all persons born within any territory held by the King of England were to enjoy the benefits of the English law as subjects of the king. A person born within the king's dominion owed allegiance to the sovereign and in turn was entitled to the king's protection. Calvin's case is the earliest, most influential theoretical articulation by an English court of what came to be the common law rule, jus soli, that a person's status was vested at birth, and based upon place of birth. In view of Sir Edward Coke, one of the judges deciding out Calvin's case, the court's determination was required by the divine law of nature, which was indeed the eternal law of the Creator and part of the law of England. So there's a reason for this agreement between the American, basically the American legal professionals and those who, uphold the English interpretation of the common law on this point, and this comes from a publication titled A History of American Law. But England remained the basic source of all law that was not strictly new or strictly American. The habits of a lifetime were not easily thrown over, despite ideology. Indigenous legal literature was weak and derivative. American cases were not commonly reported until a generation or more after independence. To common law lawyers, a shortage of cases was crippling. To fill the gap, English materials were used, English reports cited, English judges quoted as authority. In the first generation, more English than American cases were cited in American reports. Blackstone was widely used by ordinary lawyers as a shortcut to the law, and Blackstone was English to the core. So basically, the American ideology of sovereignty in the people, and so actually our Republican form of government, was muddled by this early use of English legal authorities, whose essentially has their orientation in the English monarchy, the philosophy resident in the English monarchy.
Well, it sounds like time and time again throughout American history, and actually Shane is on record as saying this. Like, he's like, well, we just essentially ended up, when it comes to the Constitution, we actually ended up kind of, for the most part, just kind of recreating a lot of the political infrastructure of England, right? So,
absolutely.
And in this case, it seems like it's not just the structure, but also folks almost, maybe de facto is the wrong word, but by default started to kind of revert back to this English interpretation of essentially being a subject versus being a sovereign individual yourself, right?
Absolutely. Absolutely. And what we're going to learn about in the third section, that's why we call it falsification, is because there's actually an agenda pushing forward all of this confusion, and it's essentially usurpation. But yeah.
Shane saying we got bullied into it by aristocratic combination.
Absolutely. Well, I actually think that what they had, if you kind of take it in perspective of the states being the things that created the Constitution, right? The states are actually the parties to that compact. Mm-hmm. And you understand that, the compact is literally there to it's a charter, right? It's there to determine, to lay out the privileges and rights, or not privileges, but the powers. That's what I was trying to say. The powers and the duties of our agents, the government, mm-hmm. right? And so, in a weird kind of way, because they have the ability to direct those under their authority, right? Like members of the government or corporations or whatever, there's just become this weird, turning things on its head, where now somehow we've become the subject of that rule, which it's like a crazy turn of events that could even occur.
Yeah, which I don't even think occurs to most people. It's like saying that Walmart has a policy for its employees, but it also applies to the customers. Like, it's not true. Like, it is not an accurate statement.
It's actually more than that. It's like,
or everyone in the world.
We're talking about it's like the Waltons, right? Mm-hmm. Those are the people who are in, not even in Walmart. They're just people who have nothing to do with Walmart other than, they're the family that owns it or that started it. And and Walmart's like, well, we made these new policies for you, Mr. Walton, Yeah. It's ludicrous. It's just outright
ridiculous. Absolutely ridiculous. All right, let's soldier on here.
All right. So to make matters worse, the congressional debates weren't released to the public until 1818. So for 20 years, the people had nothing but the Federalist Papers to inform them of the philosophical nature of their polity, and to hold their government to account the way the forefathers intended.
Yeah.
And it's really interesting when you like, we're going to talk about John Taylor's book, but when you read in there, it's so interesting to learn about how the Republican side just didn't really have a doctrine, or a written like manifest of sorts to kind of carry the ideology across generations, and that kind of did us in to a really large degree.
That is a failing. The assumption that the interpretation would never be messed with, right? Like the assumption of what they thought was absolutes, and that's why the end of this episode talking about essentially falsifying the lexicography, or essentially the words and the definitions of things, is so endemic of the issues that we have right now. So,
dude,
yeah,
absolutely. Definitely. You're going to see that word construction comes up a million times. It's really the name of the game today. This is what they're doing, other than just de facto, like, well, we have the power and we did it, so what are you going to say? I get a little more ballsy on that.
Yep.
Excuse my language, sorry.
No, that's okay.
So let's see. Chancellor James Kent was the first professor of law at Columbia College, appointed in 1793 before Columbia University instituted its law school. He also was a legal practitioner for 25 years before he became a law professor, and at the same time pursued a career as a state judge in New York. Chancellor Kent invented legal scholarship, presenting a series of lectures at Columbia in the 1820s, and then publishing them as the Commentaries on American Law, characterized by one recent writer as the most influential American law book of the antebellum period. And remember, that's only 2 years after the congressional debates are released, right? So, like, what kind of curriculum could he really have developed that wasn't going to be, missing a huge chunk of what's supposed to, determine our political existence?
Yeah.
So anyways, Kent, in those commentaries published in 1826, speaking of what he phrased the general division of the inhabitants of every country under the comprehensive title of aliens and natives, says, natives are all persons born within the jurisdiction and allegiance of the United States. This is the rule of the common law. To create allegiance by birth, the party must be born not only within the territory, but within the allegiance of the government. And that's just like the protection and the justice of the sovereign. So if a portion of the country be taken and held by conquest in war, the conqueror acquires the rights of the conquered as to the dominion and government, and children born in the armies of a state, while abroad and occupying a foreign country, are deemed to be born in the allegiance of the sovereign to whom the army belongs. It is equally the doctrine of the English common law that during such hostile occupation of a territory, and the parents, given their adherence to the enemy as subjects de facto, their children, born under such a temporary dominion, are not born under the allegiance of the conquered, but rather under the allegiance of the conquerors. And he elsewhere says, and if at common law all human beings born within the allegiance of the king and under the king's obedience were natural-born subjects, and not aliens, I do not perceive why this doctrine does not apply to these United States in all cases in which there is no express constitutional or statute declaration to the contrary. Subject and citizen are, in a degree, convertible terms as applied to natives, and though the term citizen seems to be appropriate to Republican freemen, yet we are, equally with the inhabitants of all other countries, subjects, for we are equally bound by allegiance and subjection to the government and law of the land. So allegiance has been held to mean the tie or duty of obedience of a subject to the sovereign under whose protection he is. So this would actually make sense, right? Because in the English legal philosophers could only theorize a corporate body politic in the nature of a democracy, an oligarchy, or a monarchy. So basically, those political bodies, populations, or citizens actually owe a duty to the law promulgated by those political societies. And if you remember, this has legitimacy because to the English philosophy, under the English philosophy, the law it's dictated according to the representation of the subjects that's resident in the parliament, right? And
Yeah.
even concerning, democracies, even though each person is subject to the will of the democracy, it's the idea of the legitimacy there is that each person gets an equal vote, right? And they have an equal right to an equal vote.
Mhm.
And our republic, however, was altogether too advanced for, of a political philosophy for them to wrap their minds around, and to confuse the case, as we mentioned before, most of the authorities were English.
Yeah.
So the inevitable consequence, as you read, according to English common law, is that you're a subject of the body politic whose territory encompasses your place of birth. And this is a natural, inevitable, and unavoidable political relationship theorized in the English philosophy. So in a later court decision from 1898, these remnants of English philosophy were incorporated into our system and became long-standing legal precedent. So I quote that case here. It thus clearly appears that by the law of England for the last 3 centuries, beginning before the settlement of this country and continuing to the present day, aliens, while residing in the dominions possessed by the Crown of England, were within the allegiance, the obedience, the faith, or loyalty, the protection, the power, and the jurisdiction of the English sovereign, and therefore every child born in England of alien parents was a natural-born subject. The same rule was enforced in all the English colonies upon this continent down to the time of the Declaration of Independence, and in the United States afterward, and continued to prevail under the Constitution as originally established. And then the court then cited Justice Swain in U.S. v. Rhodes. This case came from 1866. All persons born in the allegiance of the king are natural-born subjects, and all persons born in the allegiance of the United States are natural-born citizens. Birth and allegiance go together. Such is the rule of the common law, and it is the law in this country as well as of England. So this misconception, though, is, or this misconstruction of the meaning here is, I think, a result of, them not remembering the observations of Rousseau in the Social Contract. So I have this here. Even if each man could alienate himself, he could not alienate his children. They are born men and free. Their liberty belongs to them, and no one but they has a right to dispose of it. Before they come to years of discretion, the father can, in their name, lay down conditions for their preservation and well-being. But he cannot give them irrevocably without conditions. Such a gift is contrary to the ends of nature and exceeds the rights of paternity. It would therefore be necessary, in order to legitimize an arbitrary government, that in every generation the people should be in a position to accept or reject it. So while you may have a natural right to citizenship under jus soli, this doctrine can't force you to unconditionally join the American body's politic, right? To presume that would be a violation of the laws of nature, right? By exceeding the rights of paternity, and it would place us under, an arbitrary government.
Well, and so also I think, and correct me if I'm wrong, but this is also somewhat of a difficulty of applying the origins of English common law to a situation where, basically the states gain their independence from the crown. English common law, if I remember correctly, came from essentially the idea that you had essentially a tribal land, and the question was, the folks that kind of fell into the cracks were really the reason why you had common law, right? And so they're essentially applying, this tribal reasoning, where if you were born in I'm sorry, what?
Sorry, I hate to cut you off. Did you want
Go for it?
I was just going to say, not exactly. The common law, if you remember, even the term common law comes from it being the law common to all. So early on, even as early as, like 1100, there was recognition that the laws of nature, there were laws of nature, and that those were the fundamental laws that all people, have to obey. You know what I mean? No organization of men can say a thing and cause you to not have to obey, the laws of physics, right? And so obviously they were super smart and intelligent, and not that they were observing the laws of physics, but they were observing, like formal logic and sociology. But essentially, by the time our forefathers got there, it very much was the experimental sciences that just solidified in their mind, the natural law is really what it is. And as you're going to see, just in a little bit, I'm going to read a quote from Blackstone that really, like, just the whole idea here, guys, is that all governments are there to create laws to protect the rights that people have in the natural, in nature,
Mhm.
in the state of nature. And so, like, every single time, those structures that men make in order to help them protect themselves always get this other idea about what they are, and they go off the rails, destroying the very thing, those natural rights that men literally created it there to, protect and secure.
Okay. Yeah. I mean, this definitely seems like I think what you're saying from these this excerpts from Rousseau, as well as these last two cases, is essentially that the incorrect application of either the common law or what is known as common law is essentially leading them to the wrong
Well,
conclusion. Is that right?
not exactly. Not exactly. It is, because what's really interesting about this whole thing is that none of these cases are wrong, right? These cases actually all say everything you need to say, because, like, this is what I was going to say, or I mean, I was going to actually mention this in a minute, but basically, if we were joined to these political societies, it wouldn't be as a subject, right? It would actually be, being that we're the sovereignty under whose protection we're under, right? It would either be our parents,
Mm-hmm.
right? Those are the ones who, in our name and for our preservation and well-being, entered us into the society.
Mm-hmm.
But essentially, and that no one could deny us that right because of just solely. We were born here. Like, what are you talking about? But at the same time, there's no, that doesn't mean that you're forced. There's no forced condition once you're able to discern for yourself whether you want to be a part of that political society or not.
Yeah.
And even if you did choose to be a part of that political society, right, it would essentially be as the sovereign. And
Yes.
since you are the sovereign, the allegiance of the sovereign, that's your dictation. You're under your own self-government. Yes, this is all consistent, right?
Yeah.
What's
Yeah.
inconsistent is when they take these cases and they go to say, now you have to be a citizen, or you're stuck a citizen, or this means you owe a duty.
How amazing would this country be if at like age whatever 14 or something like that, like there was like this moment where they were like, okay, like, do you want to be a part of this country, or maybe even not a part of this country, but do you essentially consent to the way things are constructed?
Political body.
Yeah, and if people are like, no, I really couldn't care less about what it is, like that would be absolutely amazing. Like,
well, look, that's the whole point of him saying, like, okay, it may look like a complete left turn when Rousseau is over here talking about the rights of paternity, and then all of a sudden he's like, so an arbitrary government, you have to put the people in a position to accept or reject it. Like, where did that come from? Well, it comes from this idea that, yeah, absolutely, by the time you hit years of discretion, you should have the right to choose whether you do or don't want to be a part of a society. And that idea, is literally the difference between whether a government is arbitrary. Like, you have laws because I said so, versus you have laws because they're actually reasonable and they're part of, like, the demands that nature, places on us.
Yeah, and you agreed, like you concurred, and you were like, okay, those laws make sense. Like, all right, that's fine.
Well, you have to. Can you deny gravity?
Well, true, but I'm talking about more man-made law. But
well, no, I mean, do you break your own stuff? Like, do you know what I mean? You obey all of the laws. Does that make sense? Like, sure, you might have a hefty night of drinking, but the next morning you go, oh man, I knew the law. I shouldn't have done that.
Yeah. That's funny. Yeah. Yeah, no, the world would be a much better place if at, some age kids had to do that math or that assessment, I guess they wouldn't be kids at that time, but
literally what you're talking about, it's not like a utopia. It's literally just like getting our government back. Like, you get how that was a part of it. Being able to, like, it being not an arbitrary government, it's a government of law, right? Not an arbitrary government of men. It's not the whim of men. It's not arbitrary. right?
Yeah.
So what are we talking about?
Yeah.
Right? We're not talking about some utopian idea. We're literally talking about what our government was set up to be. And for some reason, well, not some reason, we're going to talk about the reasons, but, for these reasons, it's been, usurped. We're trying to get the government back. We're trying to get,
Yeah. Well, so your microphone got a little tinny. 1 second. I'm going to pull you out of the stream, put you back in, and see if it changes it. All right. Give it a test.
All right. How about that?
Still a little tinny, but it's better.
Okay. Do you want to take a moment?
No, that's all right. I think if it happened in the past, it was short term and it fixes itself. So just let's keep going, and I think it'll probably resolve itself.
All right. So we were talking about how being that this is a republic, if you were actually a member of the political society, then it would be as the sovereign, and so it's not just any republic, but a republic that specifically recognized the philosophy of Blackstone. And so I have that quoted here. This is what I was talking about earlier. So it says,
sure.
Civil law was only to protect the rights obtained from natural law. The primary object of law is to maintain and regulate these absolute rights of individuals. Absolute rights are those such as would belong to man in a state of nature, and which every man is entitled to enjoy, whether in society or out of society. So those of us born here don't owe any more, allegiance to, and that's the duty, right, to anyone other than or more than what we owed in the state of nature, right? And I'm sure that you're tired of me saying this, but that's essentially to not interfere with the right of others to do whatever their inclinations may suggest, so long as it's not evil in itself and doesn't impair the rights of others. Essentially, live and let live, right?
Yep.
So, if you want, we can just plow right through and head on to
keep going.
Okay, so John Taylor, he might actually be considered the leader and the biggest proponent of the ideals of the Republican Party, and I even would say that more so than Jefferson. But it's kind of remarkable that he doesn't get a lot more of the limelight. But as early as 1793, James Madison said of John Taylor, "His talents during the fraction of time he has been on the federal theater have been of such infinite service to the Republican cause and such a terror to its adversaries, that his sudden retirement, on which he is strongly bent, ought to be regarded as a public calamity and counterworked by all means his friends can use." Another senator, Thomas Hart Benton of Missouri, would remark about Taylor, I can hardly figure to myself the ideal of a Republican statesman more perfect and complete than he was in reality. Ripe in all historical and political knowledge, innately Republican, he belonged to that great constellation, or that constellation of great men who shone so brightly in Virginia in his day. Taylor had vigorously opposed most of Hamilton's program as soon as he entered the Senate. He rejected Hamilton's broad interpretation of the Constitution, the Bank of the United States, the funding program, the creation of a national debt, excise taxes, a standing army, and tariffs. He also expressed concern about the growing power of the president and the federal judiciary. And he had some things to say about the Supreme Court's presumed authority to construe the Constitution. In all ages, metaphysicians have been so skillful in splitting principles as to puzzle mankind in their search after truth, and morality itself would be lost by the minuteness of their dissections, except for the resistance of common sense and the dictates of unsophisticated conscience. And I hope you'll recognize that he's actually referring to the very things that Blackstone was talking about when he was talking about the Normans and Norman metaphysical jurisprudence. Like, it just happens again and again and again throughout history that people in power use this play of language to basically usurp their power, or usurp the authority. So let's see. If the art of construction, and remember that's construing, explaining, or interpreting words and sentences, shall acquire the power of both dispensing with the meaning of words, and also with the most conclusive current of facts by which these words have been interpreted, it will be able, like the dispensing power of kings, to subvert any principles, however necessary to secure human happiness, and to break every ligament for tying down power to its good behavior. The convention required the same sanction for both unions and for the amendments of both, namely that sanction was state ratifications. If a constructive supremacy or a final interpreter can alter the intention of the Constitution, then it would have been necessary to subject the constructions of Congress or the interpretations of that final interpreter to this prescribed mode of state ratification, or this mode would be soon rendered of little use by resorting to the constructive or interpretive mode of amendment. By wholly neglecting to guard against a constructive supremacy or a final interpreter, so evidently destructive of the federal supremacy by which the Constitution was framed, ratified, and is to be amended, it seems certain that the convention did not entertain the least suspicion that a constructive supremacy would be pretended to. In the mode of amending the Constitution of 1787, as well as in the necessity for the ratification of a state to make it binding upon that state, we discern distinctly the opinion of the convention that no American nation existed. Had it been made by an American nation, it would be a rare anomaly that state nations should have the power to reject and alter it by ratification. At the threshold of business of the constitutional debates, we clearly discern that the convention was apprised of the meaning of words. One resolution asserts that a government merely federal would not answer the call to render the constitution of the federal government adequate to the exigencies of the Union, and that a supreme national government ought to be established. Then, a rival resolution rejects the words national and supreme as incompatible with the federal union. These adverse opinions were evidently dictated, one by the political opinion already invented of a consolidated nation, the other by the actual existence of the United States. So, in other words, one of these opinions, or the opinion that supported rejecting the words national and supreme as incompatible with the federal union, was supported by the actual fact of a federal union of states under the Articles of Confederation. The other opinion of a consolidated nation was supported merely by political inventions. So the contrast between the two preliminary resolutions in a very important view depends on a single word. One proposed a supreme legislative, judiciary, and executive. The other, the same but excluding the word supreme. This word was adopted as suitable for the proposed national government and rejected as inconsistent with the federal form of government to which the states had confined their deputies. The sense in which both of these parties understood it caused its exclusion from the Constitution as inapplicable to a federal government. The advocates for a national government proposed to invest that form of government with a supreme power to, quote, construe the Articles of the Union, end quote. The advocates for a federal government originally proposed to withhold supremacy from the legislative, judiciary, and executive. As applied by the successful federal party to the Supreme Court, it evidently refers to inferior federal courts. Instead of a judiciary invested with the supreme power to construe the Articles of the Union and negative state laws, a limited judiciary is found in the Constitution. To reject a supreme legislature and executive, and yet to retain a supreme judiciary, was never even suggested by either the national or federal party in the convention. As the project for a national form of government bestowed the supremacy of construing the Articles of the Union and negativing state laws, that's just voiding state laws, upon all its departments. So, as the project for a national form of government bestowed the supremacy of construing the Articles of the Union and negativing state laws upon all its departments by plain words, and the project in favor of a federal form entirely rejected this supremacy. It is doing the utmost violence to probability to imagine that the Constitution by inference, without plain words and without its having been proposed in the convention, should have both deprived the federal legislature and executive of a power to settle the construction of our federal articles and to negative state laws, and also to bestow this enormous power exclusively on one federal court. The word supreme is used twice in the Constitution, once in reference to the superiority of the highest federal court over the inferior federal courts, and again in declaring that the Constitution and laws made in pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby. Did it mean to create two supremacies, one in the court and another in the Constitution? Are they collateral, or is one superior to the other? Is the court supreme over the Constitution, or the Constitution supreme over the court? Are the judges in every state to obey the Articles of the Union, or the construction of these articles by the Supreme Federal Court? The project for a national government gave a supremacy over the articles of the Constitution it advocated to the legislative, judiciary, and executive, and did not propose that the Constitution should be supreme over these departments because it would have involved a contradiction. As they were to have had a supreme power of construing its articles, these articles could not possess a supreme power over their constructions. But a federal system required that the Articles of Union should be invested with supremacy over the instruments created to obey and execute them. In all treaties, the right of construction must be attached to the right of alteration, or the latter right would be destroyed. The supremacy of the Constitution is an admonition to all departments, both state and federal, that they were bound to obey the restrictions it imposes. In relation to the federal government, it literally declares that its laws must conform to its exclusive and concurrent powers. And in relation to the state governments, it implies that theirs must also conform to their exclusive and concurrent powers. It neither enlarges nor abridges the powers delegated or reserved. And it is enforced not by an oath to be faithful to the supreme constructions of the federal departments, but by an oath to be faithful to the supremacy of the Constitution. And I quote Thomas Jefferson here saying, "To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." John Taylor published his book New Views of the Constitution in 1823. This was 5 years after the constitutional debates had been released. Mm-hmm. And he exposed a nationalist agenda among our government officials using the abuse of construction. It was used to set up a national regime with citizen subjects of the general government and subordinate federal districts which surrendered their sovereignty to a central authority, as we'll discuss next.
Yeah. Well, so my understanding here, and so, speaking about supremacy, specifically in reference to, say, like the Supreme Court, right? My understanding is that the original interpretation or the original intent of the court was simply to be one more of guidance than of actual final ruling, right? Because for the most part, go ahead.
Not exactly. Okay. It was to be one of final ruling, but it was to be one of final ruling over the federal courts. The federal courts are, creatures of the Constitution. They're created by it. They are not the Constitution itself. So it would make sense that it would be within the purview of a court created by the Constitution, a Supreme Court, to have the final dictate on an inferior federal court, not a state court, certainly not a state Supreme Court, certainly not the people, that is a jury, and what was the other part of it?
Yeah, because the misconstruction or how it's misconstrued now is that when the Supreme Court rules, that it then becomes essentially a how should I put it? Just a universal interpretation, right? Like that. If the Supreme Court says, what was that?
Sorry, the Supreme Court says.
Yeah, if the Supreme Court says that something is or isn't constitutional, or a ruling or a piece of legislation or something like that, all of a sudden everyone automatically assumes that now applies to every single individual within the United States,
right.
which is not accurate. It applies to anything that was germane to, that federal court ruling that was subservient to or inferior to the Supreme Court. Right.
Of course, U.S. citizenship creates a little bit of a fuzzy area there where they're going to try to assert things that they really have no power to assert.
Right.
But I was going to say, you might be surprised to learn that it's actually the Supreme Court's ruling that determined that the Supreme Court would have final say.
Yeah, that's true. They gave themselves final say.
Yep. You learned that in Criminology 101, man.
It's good work if you can get it.
Oh man, that's funny. Yeah, so that other thing I was trying to remember is that it certainly doesn't have any say over the Constitution, the actual charter that created it.
Yeah.
I mean, it would have even less control over the states, and then even less control over the people, because the states are really just representative of the people.
Well, and again, we're also kind of like this is like how should I put it? This is like, chasing a bulb that's out in a string of Christmas lights, right? Because you have these things that kind of compound these problems, and so when you have at the base of it kind of misinterpretations or the in some cases the deliberate change of definitions of certain terms and things like that. I mean, ultimately, a Supreme Court ruling was not meant to have the gravity that it currently has, right? Like
Right.
the Supreme Court ruling was essentially supposed to say yes or no as to whether or not the federal courts and thus whatever the contention was, which was typically whether the federal government was overstepping its powers or not. But those powers that the federal government was bestowed with were ridiculously limited. And so the Supreme Court was just supposed to kind of like, essentially keep them in their lane, so to speak. But it is now something where that interpretation of what a Supreme Court ruling is and the ramifications have become completely flipped on their head, or they've
Yeah.
created this basically leviathan
Well,
of an entity.
think about how ludicrous this is, right? Because like how ludicrous the conclusion that the Supreme Court has this final say. So first of all, you should see, I'm pretty sure it's in the Constitution, it says the legislation of Congress shall not, or legislation or jurisdiction of Congress shall not extend beyond, like 5 miles square. It's talking about the District of Columbia. It's not, it's not allowed to be all over here, but the U.S. citizenship thing makes a little bit of a difficult or a different kind of a story that you might have to actually argue. But essentially, the I was gonna say, oh man, I totally just lost my train of thought. I'm so sorry.
That's all right. But it is this compounding effect where at the base levels of interpretation or in application, if a definition becomes misconstrued, or if the extent to a power that is afforded by the Constitution, or at least allowed at the federal level, now all of a sudden when you allow that to balloon, then the overall impact of all of the other things that are supposed to be tasked to the federal government balloon as well. And so
Well, that's true, but honestly, I don't really see it that way. And
okay.
the only dynamic factor that we're missing, so that I see it exactly the way you do, except for this one factor, is education. In the past, we literally had a class called civics that taught you about, it was a class on philosophy, right? That philosophy dealt with natural rights. And like I said, the government got its fingers in the education system and perverted the civics doctrine, and essentially, left everybody ignorant. And the consequence of that is that no, our government is literally set up for every single individual. Okay, look, our government recognized that people exist in the state of nature, and you cannot force them to do anything, right? So how could you have a government official do his duty if you can't force him? We created an oath. That's the whole idea. Our entire government is voluntary based on the oath. And the oath precedes everything. It's more fundamental to everything else. And that is because it makes them personally liable. So there's everything else, but you could actually put this individual in jail, or as you've observed, to death. So, I mean, it behooves them to take their oath seriously. And so the way that, that dynamic factor, it's exactly what you're saying. But if you had everybody educated, they would stand on their oath. You know what I mean? They're like, I'm not getting in trouble for that. I'm not doing it. I'm not risking my life for whatever you think whatever process you think I'm supposed to implement, or whatever, what statute you think I'm supposed to enforce, or whatever.
Well, not to mention the fact that the enforcement mechanism is individuals also understanding.
That's what I mean.
The place of that individual.
The entire government is literally capable. Every single person at every stage of the government is capable of stopping injustices. Like all of them. They all have that within their right under the Ninth Amendment, and just the general constitutionality of all the other topics that generally get infringed.
Yeah.
Yeah.
And when all else fails, the final, the final straw is the individual ultimately, which I think is also something that has been lost, right? Like, or not the
Well,
final straw, but
I
the
think
Alamo, so to speak.
I think well, I don't know. I mean, I kind of take the disposition of the founding fathers that there's providence here, man.
Mm.
God wants us to be free, and He's
Yeah.
given us the tools to do it. And these are them, right?
Yeah.
Understanding our existence in relation to nature and political societies is really at the heart of correcting everything that's been gone wrong.
Yeah.
Yeah.
Lest we become, I forget the phraseology, but essentially slaves, right? Like,
I was thinking slaves.
yeah,
In case you didn't think of it, I was like, he's thinking
yeah,
slaves. Yeah,
yeah.
man. Totally.
So, all right, let's keep pushing forward. All right,
All
Jefferson.
right. So here we go. Wait, Jefferson? No, I think we are
Oh,
we already
sorry. Oh no, we're on to
we're there.
lexicographic
Yep.
falsification.
So lexicographic just refers to the writing of dictionaries, okay? The study of languages. But a pair of volumes of dictionaries from Webster's, one printed in 1863 and the other in 1864, appear to evidence a professional lexicographer may have colluded to purposely falsify the definition of certain words. It appears this was intentionally done to alter the comprehension of the general population in America and elsewhere in reference to the meaning of the words at the time of the constitutional conventions. By altering the definitions of the words, the accurate, lawful, and proper application of the Constitution could be misconstrued to deceive the people, so they would accept explanations that were false and misleading. So it becomes an important question, right? When courts say the Constitution must be read within the meanings or with the meanings of the words when it was written, have they gone to the original meanings or to the altered meanings? For instance, the definitions of federal, confederation, state, e pluribus unum, Congress, alliance, democracy, and union appear to have been changed for the purposes of influencing the promotion of a national government distinct from the general government established by the Constitution for the United States. So first, we're going to check out a couple of these definitions. So Congress, from Webster's 1844 edition, and this was retained until 1864, the assembly of the delegates of the several British colonies in America, which united to resist the claims of Great Britain in 1774 and which, in 1776, declared the colonies independent. The assembly of the delegates of the several United States after the Declaration of Independence and until the adoption of the present Constitution and the organization of the government in 1789. The Assembly of Senators and Representatives of the United States of America, according to the present Constitution or political compact, by which they are united in a federal republic. And so here we go to the 1864 edition. Congress, after 1863, the Assembly of Senators and Representatives of the people of a nation, especially of a republic, for the purpose of enacting laws and considering matters of national interest and constituting the chief legislative body of the nation. The Articles of Confederation came into force in 1781, so for 5 years the states acted as independent colonies. To contend that they were a consolidated nation at the time of the constitutional debates would have been ludicrous, right? So for 83 years, the Congress represented independent states that were united in a federal compact, a confederated union, of sovereign states, to then, at the whim of a lone lexicographer, be changed into representatives of the people of the nation and elevating its status to the chief legislator of that fictitious nation. Right? Manifest changes to the nature of government and its people without a single vote or a firing a shot, all with nothing but common dictionaries. Like, that's wild.
That is egregious. From I mean, to someone it might seem like an innocent or a unintentional change in phraseology, but
Right.
from my perspective, that is an egregious
Right.
change philosophically, from the idea that these are representatives of the states to now representatives of the people of the nation.
Yep.
Which
And now they legislate the laws for the nation.
I mean, to anyone who sits there and goes, "Oh, we're a democracy," that's why they probably have this ridiculous idea of what that
Right.
means. Like, or we
Yeah.
have representative government. Well, representative of what? It's not representative
Yeah.
of
This
you
is
directly.
this is one of the things that the nonprofit, the American Natural Rights Foundation, has actually had to face, is because depending on where you are and what level of government you're dealing with an entirely different political philosophy that underpins their, what they think they're doing and what they use, the lens they use to interpret what you're doing.
Yeah.
You know,
Yep.
so yeah, it's been pretty interesting to have to learn some quite different. There are like four contending theories currently, basically that we think are currently running in different portions at different levels of the government. It's pretty pretty funny.
Unbelievable.
um,
All right.
yeah.
So
So
federal.
yeah. So also, I was gonna actually comment. We're gonna talk about how we're gonna actually ask the question: was this an honest mistake? Right. So we'll get there. But first, let's
Okay.
take a couple more examples here. So we got federal before 1864, pertaining to a league or contract derived from an agreement or covenant between parties, particularly between nations, consisting in a compact between parties, particularly and chiefly between states or nations, founded on alliance by contract or mutual agreement, as a federal government, such as that of the United States. So it even references the United States. And then federal after 1863, specifically composed of states or districts which retain only a subordinate and limited sovereignty, as the Union of the United States or the Sonderbund of Switzerland. And from
Wow.
Webster's seventh, yeah, right. And from Webster's seventh New Collegiate Dictionary, so this was published in 1965. Federal, archaic, of or relating to a compact or treaty. Two, formed by a compact between political units that surrender their individual sovereignty to a central authority, but retain limited residuary powers of government. Of or constituting a form of government in which power is distributed between central authority and a number of constituent territorial units. So they changed from the sovereign parties to a compact to subordinate constituent territorial units, which surrendered their individual sovereignty to a central authority by no other way than Webster's dictionary. So, yeah, like, isn't that crazy? Something
That's
here too. Sorry, did you want to say something?
no. I'm just saying that's unbelievable. It's like it is completely sullied. I mean, the what constitutes what is, just the meaning of the word federal with reference to a government institution. They've essentially, just redefined it into being this, supreme being.
Yeah. You want to know what's funny? Check this out. My local library in my city has a whole podium set there, established a little thing with an 1864 version of Webster's dictionary.
With 1864, not the one prior.
Well, that's what we're talking about. Essentially, there's an overlap. So both were published during the year 3 and 4, or
Okay.
you know what I mean. But then 60, the version that existed up to 64 didn't exist anymore, and the version that started in 63 continued into the future. So
Okay.
it was really 63 is the perverted one, but because the regular one actually prints until 64, it's like it's inverted like that.
Yeah.
But yeah. So I was going to say something worth noting here is that basically words lost to obscurity are not from like a lack of common usage. They're not recorded in the dictionary, right? So the use of the term, the designation archaic there, it's actually a reference to the fact that the term still has applicability to instances of the past, to archaic instances. And so the adoption of our Constitution, and how it's interpreted would be one of those archaic instances where it would still have validity. So it's just a really it's just
so they retroactively did it basically.
Yeah. Well, you can see how bad it went. It went from what were the dates on that? It was like or we had 60 or 44 to 63 to 95, I think it was, right?
Yeah.
Or was it? Sorry, I kind of lost my place.
To 65.
Yeah. Yeah. So anyways, like you can see how bad it's gotten.
Unbelievable. And so
So
it doesn't even just stop there, right?
So additional dictionaries other than Merriam-Webster Company participated in this manufacture of new definitions. However, it appears that in 1864, absolutely no other dictionary in the world carried the same definitions as this edition from Webster's above cited. And it would be important to note here that even the Merriam-Webster Company had for 36 years stuck with the original and true definitions. And only after the appearance of that corrupt edition in 1864 did the other dictionary companies follow the trend. So, for example, a standard dictionary of the English language, turning to the word federal, this new company, having just begun in 1890, put in their edition, their 1895 edition, of or pertaining to or founded upon and organized by a compact or act of union between separate sovereign states, as by a league for common interest and defense as regards external relations, the internal sovereignty of each member remaining unimpaired, as the Hanseatic League or the Germanic Confederation, or by a permanent act of union founded on the consent of the people duly expressed, constituting a government supreme within the sphere of the powers granted to it by that act of union, as the United States of America. The Constitution of the United States of America is of a very different nature from that of the Germanic Confederation. It is not merely a league of sovereign states for their common defense against external and internal violence, but a supreme federal government or compositive state acting not only upon the sovereign members of the Union, but directly upon all its citizens in their individual and corporate capacities. So we just went from the sovereign people of the several states of the Confederated Union to being citizen subjects of a supreme and permanent government, all by way of a dictionary.
Unbelievable.
Yeah, isn't that funny? So sorry, were you going to say something?
No, I mean, all without constitutional amendments or anything to the effect, just strictly a change in how we refer to certain words.
And remember, this is because back in the past, Confederate and federal were synonyms, right? So why was it called the Federal Party and it was talking about state sovereignty? Because that's the nature of the Constitution, of the compact, that it's a federal compact. But we've become so uneducated, so ignorant about everything. Just our history, the language, the law, political philosophy, that the end result is essentially, it's like everybody knew better back when they were trying to usurp the authority back then, right? So Taylor, all he's got to do is get out his book and be like, look, guys, that's not what was okay. That's not how it went down, right? And everybody's like, oh shoot, we got caught. We can't do it anymore,
Yeah.
But like, they obviously figured out that if they could pervert the dictionaries in a few generations, hey, same scheme, still works.
Well, it's essentially like, all right, well, they just needed a different knowledge base to draw back on to say, oh, nope, see, that's the way it's supposed to be, right?
Exactly, to contend with Taylor's arguments. Totally.
Yeah. Unbelievable.
So another dictionary titled New World Edition, state pre-1864, a political body or body politic, the whole body of people united under one government. So it's literally the people in political capacity is equivalent to the state. That's what it was before 1863, right? Which is why the state is our agent, because we're the state, right? Yeah. Those people over there who sit in offices, those aren't the state. We're literally the state.
Yeah.
So they're in our political capacity, right? Obviously, we could be in a state of nature, and then you just be a natural human being. But so state post 1863 in the United States, one of the commonwealths or bodies politic, the people of which make up the body of the nation, and which under the national constitution stand in certain specified relations with the national government, and are invested as commonwealths with full power in their several spheres over all matters not expressly inhibited. Webster's 10th Collegiate Dictionary, state, and this is from 2001, is defined as one of the constituent units of a nation, having a federal government, the 50 states. So do you see how much they just changed the definitions from the original? Like,
I mean, they've essentially turned free men into slaves by essentially saying that, by essentially just changing the definition of the units of how the government is essentially segmented. I mean, it's
Uh-huh.
like it's incredible. I mean, so
Absolutely.
so the question then becomes, all right, was this innocent? Was it coincidental, or is this a methodical or premeditated change in terminology?
That is correct. That is a question that we are going to ask, but we have to take a moment and listen, or we have to take a moment and hear from Taylor.
Okay.
So we're going to read an excerpt again from his book, New Views of the Constitution. And so he makes the following observations concerning the word national. The word federal, also adopted into our political phraseology, is a national construction of the terms used in forming our system of government, comprising a definite expression of public opinion that state sovereignties really exist. It implies a league between sovereign nations and has been so used by all classes of people from the commencement of our political existence down to this day, and is inapplicable to a nation consolidated under one sovereignty. Had the journal of the convention which framed the Constitution of the United States been published immediately after its ratification, it would have furnished lights toward a true construction sufficiently clear to have prevented several trespasses upon its principles and tendencies toward its subversion. Perhaps it may not yet be too late to lay before the public the important evidence it furnishes. A short history of the convention itself will enable us to understand its proceedings. A meeting of deputies from several states in 1786 at Annapolis recommended the appointment of commissioners to devise such further provisions as shall appear to them necessary to render the Constitution of the federal government adequate to the exigencies of the Union. And Congress in 1787 recommended a convention of delegates to be appointed by the several states as the most probable mean of establishing in these states a firm national government. The recommendation of Congress comprises a national government, a federal constitution, the preservation of the Union, and a convention for the sole purpose of revising the Articles of Confederation. These recommendations are at discord with each other, as a national and federal form of government are not the same form. Let us see how these recommendations were received by a concert of states. 12 states appointed deputies to assemble at Philadelphia, and each gave its deputies credentials specifying their powers. The idea that the recommendation of Congress was addressed to an American nation or people nowhere appeared, and that of a national government was rejected in every state. The powers to these deputies are the following, and so feel free to go back and take a look at these, but essentially they're all pretty much the same for the most part, so I'm just going to read Connecticut.
Sure.
I think it's pretty much sums up the whole thing. For the sole and express purpose of revising the Articles of Confederation, to render the federal constitution adequate to the exigencies of government and the preservation of the Union. So, thus, the states unanimously rejected the recommendation of a national government, and by excluding the word national from all their credentials, demonstrated that they well understood the wide difference between a federal and a national union. The distinction was enforced in Massachusetts and Connecticut by the word sole purpose. The reference of sole is to the word national used by Congress, and in all the credentials, the word federal is used also in opposition to the word national. There existed no other object but the suggestion of a national government, for the restrictions in the credentials of the states to operate upon. And their unanimity without consulting each other is a complete proof that they all comprehended the difference between a federal and a national form of government. The word constitution is also uniformly considered by the states as equivalent to the word confederation. So John Taylor's book had the effect of stopping the national thrust of the federal government in 1823, and the issue over a lack of delegated power, delegated authority to create a national government being made clear and laid out. Basically, there was no argument that could be made, for that cause. Mm-hmm. So this work by Taylor would actually be the cause for the following resolutions entered into the Congressional Record in 1833 by John C. Calhoun. And so it reads, resolved, that the people of the several states composing these United States are united as parties to a constitutional compact, to which the people of each state acceded as a separate sovereign community, each binding itself by its own particular ratification, and that the union of which said compact is the bond is a union between the states ratifying the same. Thus, not a union of all the people in aggregate, but as a union of sovereign states to which those people belong. Resolved, that the people of the several states thus united by the constitutional compact, in forming that instrument and creating a general government to carry into effect the objects for which they were formed, delegated to that government, for that purpose, certain definite powers to be exercised jointly, reserving at the same time each state to itself the residuary mass of powers to be exercised by its own separate government, and that whenever the general government assumes the exercise of powers not delegated by the compact, its acts are unauthorized and are of no effect, and that the same government is not made the final judge of the powers delegated to it, since that would make its discretion, and not the Constitution, the measure of its powers, but that, as in all other cases of compact among sovereign parties, without any common judge, each has an equal right to judge for itself, as well as of the infraction as of the mode and measure of redress. So this next part, it's stated in the affirmative, but right at the end, he negates it, so basically saying how ludicrous they are. So just in case it's hard to follow along. But reserved, that the assertions that the people of these United States, taken collectively as individuals, are now, or ever have been, united on the principle of the social compact, and as such are now formed into one nation or people, or that they have ever been so united in any one stage of their political existence, that the people of the several states composing the Union have not, as members thereof, retained their sovereignty, that the allegiance of their citizens has been transferred to the general government, that they have parted with the right of punishing treason to their respective state governments, and that they have not the right of judging in the last resort as to the extent of powers reserved and the consequences of those delegated, are not only without foundation in truth, but are contrary to the most certain and plain historical facts and the clearest deductions of reason, and that all exercise on the part of the general government or any of its department claiming authority from such erroneous assumptions must of necessity be unconstitutional, must tend directly and inevitably to subvert the sovereignty of the states, to destroy the federal character of the Union, and to rear on its ruins a consolidated government without constitutional check or limitation, and which must necessarily terminate in the loss of liberty itself. So you can imagine how well that stopped national thrust, right?
Yeah.
Pretty much. I mean, that's on the congressional record. Those resolutions were passed. There's nothing you can really do about that.
Yeah, and of which, to anyone who is like privy to any extent of American history in terms of the way this, the revolution plays out, and in terms of how the beginning stages of this confederation or federation plays out, that would be in line with their view, right? Like, why would we ever surrender substantial powers to this centralized government or the centralized seat of power after we had just escaped a single individual who was a centralized seat of power?
Exactly. Yeah. Yep, you have it right there. That's exactly right. So essentially, right, they took to lexicographic falsification to destroy the ability of the American people and the states to defend against a national consolidation under a central authority at a later time. So you keep asking the question, and here it's finally come up. So we can definitely take that under review. A historical review might help to understand the lexicographer behind those many falsified definitions. Prior to 1864, there were two dictionaries that enjoyed equal market share in homes, classrooms, and libraries. The Dictionary of the English Language by Joseph Worcester and Webster's Dictionary. That is Noah Webster's Dictionary. Different person than Merriam-Webster. By 1830, Webster charged Worcester with plagiarism, and that began what became known as the Great Dictionary War. Though the plagiarism charge was dismissed early in the war lasted until Worcester's death in 1865. Noah Webster, the author of spelling books which dominated the American market at the time, spent decades of researching and compiling his dictionaries. His first dictionary, a compendious dictionary of the English language, appeared in 1806, and in 1828, his American Dictionary of the English Language was published. Noah Webster died in 1843,
And a lexicographer named Noah Porter worked for Merriam-Webster Company from the start, but they bought out the rights to continue Noah Webster's works after his death. Looking at all dictionaries from 1847, that's when the first Merriam-Webster edition was published.
Mm-hmm.
It is clear that from 1847 to 1863, Noah Porter maintained the former correct definitions as laid out by Noah Webster. Since Noah Webster, in all his efforts to define these keywords having to do with the understanding of our government maintaining the United Confederation, no editing was called for in 1847 or for the next 16 years of the state's political existences. And we should also take note that when the words were falsified, Noah Porter and the Merriam-Webster Company stood alone in the whole English-speaking world as to these new meanings. All lexicographers, including Samuel Johnson, Boegs, Walker, and Joseph Worcester, maintained that federal meant a league or compact, therefore a confederacy. Noah Webster and the entire realm of lexicography, along with Porter, had been agreed on this for decades, but in 1864, Noah Porter and the Merriam-Webster Company sent the people of the United States into an obscurity of meanings and concepts. Another interesting point of historical fact is that the 1864 American edition made these changes while the same staff left alone the previous definitions and did not alter them in one edition. The American edition alone had been reconstructed. London and all of the other English-speaking countries received their 1864 editions with the proper definitions intact, though both the American and the London compilation came from the same staff. Not until 1877 was it presented with the false definitions. This enlightened revelation by Taylor leveled any national theory before it could utter a syllable of untruths. The reply was to begin a wrecking campaign against all lawful states' rights doctrines, and since that couldn't be accomplished with the truth, it had to be done with deceit. The principles laid out by our Confederated States would now come under attack from iconoclastic sophists, rather than stand as the true meanings well understood by our forefathers. Slavery as the front issue caused so much confusion that the actual form of government might be overlooked. Realizing in 1864 that the aggressors would win as far as physical force was concerned, now the power of information had checked the eventual instigators of that war in 1823, which should rise again. First, they began by smuggling false definitions to the people under the wraps of a famous dictionary. The Merriam-Webster Company having gotten control of the name when Noah Webster died. Next, find a way to do away with the equally noted dictionary by Joseph Worcester. Remember, prior to the Civil War, during the Great Dictionary War, all the literati of the times esteemed the works of Noah Webster and Joseph Worcester as those of superior lexicographers. So exactly what happened that one of these disappeared into obscurity, where the other kept its household popularity? Worcester's 1864 edition, all issues thereafter, never falsified these words, and even in supplements pointed out that changes were due to the so-called Civil War. As late as 1904, which is the latest publication, it still retained the true definitions. The new federal regime after the Civil War displayed signs in government printing offices instructing proofreaders, editors, and compositors to quote-unquote follow Webster. And then the Merriam-Webster Company bragged of its pedigree by claiming that Webster was the choice of the courts in some of their old dictionaries. The page can be found quoting Supreme Court justices praising the work of Webster. Dr. Oliver Wendell Holmes, a Massachusetts Supreme Court judge who later go on to become a U.S. Supreme Court judge, announced publicly that he preferred Webster over Worcester, but the final blow came when Charles W. Eliot, president of Harvard, wrote in 1900 that he made use of Worcester's for the past 10 years, but now would happily replace Worcester with Webster. And it might be interesting to note that Eliot actually called the Merriam-Webster dictionary the revision. And I have a quote here from Robert Keith Levitt, who was a Harvard-educated New York advertising copywriter who authored many books including The History of Webster's Dictionary. In his book titled Noah's Ark, New England, Yankees, and the Endless Quest, he says, the West Point cadets were furnished with a copy of Webster for each room and required to keep it in good condition. Schools in state after state and city after city, prodded by a well-organized adoption campaign from Springfield, standardized on Webster. Legislatures made Webster their authority by resolution, and courts followed this lead right up to the Supreme Court of the United States. In every executive department of the federal government, Webster was the authority. This despite the fact that many other English dictionaries were still being published and remained available, such as Johnson's, Walker's, Bailey's, Boegs, and foremost Joseph Worcester's, not to mention a dozen other fully qualified lexicographers. And so it might also be of interest that heads of imperialistic countries, such as the King of Siam, the Sayyid of Aleppo, and even China, actually flocked for the right to make Webster's the chief dictionary for educating their subjects.
Okay.
These dictionaries from Webster and Company wouldn't be the only sources claiming authority to determine the nature of our government and the extent of its powers. So History, the popular American television channel, and their online publications would say this in reference to the Federalist Papers. In October 1787, the first in a series of 85 essays arguing for ratification of the proposed U.S. Constitution appeared in the Independent Journal under the pseudonym Publius, addressed to the people of the state of New York. Essays, now known as the Federalist Papers, were actually written by the statesmen Alexander Hamilton, James Madison, and John Jay, leading supporters of the Constitution and the strong national government it created. And from the Encyclopedia Britannica, which acclaims of itself the world standard in knowledge since 1768, said this about the Federalist Party. By 1817, the party was practically dead, though the opposing Republicans had adopted the Federalist principles of nationality. Can you hear that? And had accepted many of their economic ideas. The accomplishments of the Federalists were great. The party organized the enduring administrative machinery of the national government, fixed the practice of a liberal interpretation of the Constitution, established traditions of federal fiscal integrity and creditworthiness, and initiated the important doctrine of neutrality in foreign affairs. And if you remember earlier in our talk, Taylor definitely puts to rest all of these assertions. Like all of these are false.
Yeah.
Right? And this right here, this next one is a preview of what we're going to go into more deep next time. But this is from the New Lexicon Webster's Dictionary of the English Language from 1959. And they would say this of the role and duties of the president. The role of the president has expanded considerably beyond that envisaged by the founding fathers of the Constitution. Like, by what right? During such crises as the Civil War, World Wars I and II, and the Depression of the 1930s, Congress and the nation both turned to the executive for leadership and guidance. Crisis powers given to the president were to a great extent retained afterward, again, by what right? Thereby adding new stature to the office. Likewise, as foreign affairs increased in importance during the 20th century, the president's role as voice of the nation added new prestige and responsibilities to the office. Governmental efforts to provide for the economic welfare of its citizens initiated in the Depression of 1929 to 33, and subsequently expanded, have contributed to the president's duties and powers in the economic and social spheres. Likewise, the need for an expanded bureaucracy. Serving the president has heightened his prestige and influence at the expense of the legislatures. So by mere assertions alone, the judiciary, the executive, the common dictionaries, and now all sorts of seemingly innocuous sources of historical information get the political philosophy of the United States of America so wrong. And this has the unfortunate consequence of erroneously influencing the political conceptions of the American people in their attempts to understand their government and their history. And there's just one, I know we're totally way over time. There's just one last part, which is, these are a pair of graphs that show the Supreme Court's reliance on dictionaries over time. So in that first picture, you might be able to see there's kind of there's something kind of like gray and hazy over the left side. Do you see it right there? That's actually a pinpoint of when Webster's dictionary was, right there, is when Webster's corrupted dictionary was first published. So you can see this goes from 1860, or the whole thing is 1842 to 1992. But you can see that it starts to ramp up really right in 1864, right? And it just goes crazy off the bat. And so what you're seeing on the left side is, this is percentages. So what you're seeing is around 33% by 1992. So if it's following the same trend, right, you can imagine it's probably a lot, what is it, 8 in 10 cases now? Yeah. And this other one is just another term, 1935 to 1992, just to show it a little bit clearer. One of these has to do with percentages calculated based on a number of signed opinions in each term. and this other one lists cases that includes the word dictionary or dictionaries in reference to the U.S. cases. So.
Yeah. Well, so all right. So I think that shows the application of these new interpretations or new definitions, right? And so to that point, we do have a viewer that has a question, and Ron's asking, where do definitions come from? All right. And so I think the traditional explanation of where definitions come from is essentially the kind of common use of the words during the time, right?
For a lexicographer, yes.
Okay,
For a
so
person who studies languages, yes. But for a person who studies political philosophy, it would actually be, the most fundamental political philosophy, which is the natural law.
yeah, and so that makes sense. So the question becomes, all right, so in this crossover between 1863 and 1864, the Civil War is happening. The people that are more pro-centralized government seem to be winning. And the definitions change. So do we have reasonable expectation that it's those dynamics, or is it simply that people more often are... I mean, where was Merriam-Webster's located out of? Was it a Southern company or a Northern company?
I don't think it matters, because as you can see from what we went through, because as you can see from what we went through, Merriam-Webster agreed with everyone else up until, the third year of the Civil War.
Yeah.
Right. That doesn't make any sense. There's no justification. There's nothing that could create other than I'm deciding my political opinion is going to influence a whole population because my dictionary, well, it's not that it even is that popular. It is very popular, but it became the standard on a campaign from Springfield, right? Well, you wonder why.
Yeah.
Right.
Yeah.
Springfield is the government.
Yes. And it's also, I mean, of note, they are mostly a Northern company, right? So I think that might also have painted that interpretation, whether, whatever kind of dynamic you think existed there. I mean, that's where they're located. So, I mean, that comes into the context. But so from that standpoint, yeah, I think some people would say, oh, well, language changes over time. But the issue is that language changes for the things that are created during that time period, right? Not for the things that predate it and then you retroactively apply those definitions.
Okay,
right?
I think I see what you're saying. Here's the answer to the question. What were the deputies authorized to do? Were they authorized to create a national government? Then no protection to a national government can be pretended.
They most certainly were not.
Right? Yeah, exactly.
Yeah.
So that's the end of that question.
Yeah.
There's no debate there. You know what I mean? It's clearly that the debate was over with Taylor. Right? Those resolutions entered in by John C. Calhoun. Why do you think they put him in fourth grade social studies books and make him a demon of a racist, right? And a slaveholder, right? It's because, of course, you're not going to go and listen to what he has to say. Did you hear those resolutions? Those were remarkable. Right.
Well, and in addition to that, one of the, I forget if it was the definition of federal or one of the definitions that appears in a later edition of a dictionary, you said uses the word archaic, which essentially says that, okay, we're going to now retroactively apply this definition to everything that preceded it. Preceded?
Well, no,
I always screw that up, but...
Archaic makes it, it's sophistry. It's like their attempt to trick you into thinking that the word archaic refers to the idea that nobody uses it that way anymore.
Yeah.
Well, that's actually true, but saying the phrase nobody uses it that way anymore creates a stigma that the connotation doesn't. Factually, nobody does use it that way anymore, except for in archaic instances, in those instances of the past where it has application.
Yeah. Well, and that is also part of this aspect of revisionist history in the day and age that we live in, right? We try and interpret historical events using, present day machinations or structures or definitions and things like that, and it does not apply because during that time period when that document or when those conversations are happening. I mean, this happens with the Second Amendment all the time. What does the word regulated mean? right?
Yeah.
It does not mean restricted. It doesn't mean the word restricted, right?
Yeah. It just means, I was going to actually, I wanted to just just kind of devil's advocate, but kind of point out a particular thing.
Sure.
Of course I'm going to lose my train of thought. It happens right when I'm about to talk. I was going to say, basically with Taylor, right? The entire national thrust was put to bed with Taylor and with those resolutions, right? So they obviously had to go to falsifying the definitions, like you said, so that when we actually had the debate again, we couldn't actually, stand on our 2 feet, because they would say, "Oh, look, it always was,"
Yeah. Yes. Yeah. No. And I think that is really the crux of it, right? Like, even if language changes over time, I mean, not to mention the fact that we have already covered in prior episodes talking about the folks that essentially dreamt up the way things were supposed to be essentially organized or divided out, right? They essentially said that, a constitution that has relative language in it is effectively worthless, or even worse, because there's no consistency or dependability in the interpretation therein, right? So that kind of constitution, if everything's relative, then shit, all bets are off. We could just define anything the way we wanted to.
That's a fantastic critique, but it honestly lost its wind because a majority of the people at the time who were involved with the thing were very well educated. So they just didn't, properly conceive of the time when that argument was going to be of paramount significance.
They unfortunately estimated that we would get smarter over time and not dumber.
Well, no, look, this is why I always go in defense of America, because you can see not a moment have we had to breathe. Like we just wanted to fucking, excuse me, we just wanted to, and it's just like, we've been attacked this entire time. I didn't even teach or, tell you guys about all sorts of different, just the worst kind of nefarious behavior that you would just be like, you got to be kidding me. You just snarl at it, because it's just like, wow, man.
Well, you're talking about surrounding all this back and forth, right?
All sorts. I'm talking about, because we just span, a lot of time. Back from before, when they're proprietary colonies, all the way up into, 1864, you know what I mean? Like, we spanned a lot of time where there's so much history in there that shows that America has been, the American people, the American body's politics have been attacked this entire time, from within and from without. And it's just like a multitude of different things we've had to contend with in it. And so I come to the defense in America when people, look down on us. Like, we've actually done remarkably well for how attacked we are. We still are. What's coronavirus, man?
Yeah,
it's an attack. What it is.
Well, it's an internal minority. When it is internal, it's an internal minority attacking for the purpose of gaining control, which is what it always seems to be. But all right, we will leave it there tonight. Look, thank you again, Josiah. Everyone definitely check out ANRF. So it's mt-anrf.org. And some of this fantastic work that's happening. I think there's also, is there an option to donate there too?
Not yet. We're currently getting that set up, but maybe I'm trying to look into that. We're basically trying to get it set up currently. I don't know when we'll be able to have it ready, but I was going to say we're definitely interested in volunteers. If anybody wants to take part, we'd happily take people interested in coming involved.
Awesome. Yep. Yeah. If you are interested in doing some of this research or helping to do some of this research, definitely reach out. And any little bit helps because it is a Herculean effort. But so we will be back in 2 weeks for Natural Rights Talk, and I will be back Monday at 7 p.m. So you got 2 weeks to give us drop some more bombs on us here,
Awesome.
Josiah.
All right, thanks, Matt.
All right. So
forward to it.
everyone have a good evening, and I will see you back here Monday evening at 7. Thank you all.